Welcome to the 34th meeting in 2025 of the Delegated Powers and Law Reform Committee. I'd like to remind everyone to please switch off or put to silent their mobile phones and other electronic devices. The first item of business is to decide whether to take items 6 and 7 in private. Is the committee content to take these items in private?
Yep. Yes.
Under agenda item number 2, we're considering an instrument subject to approval by resolution. No issues have been raised on SSI 2025-353. Is the committee content that no reporting grounds are engaged?
Yes.
Under agenda item number 3, we're considering instruments subject to the affirmative procedure. No issues have been raised on the Draft Education Scotland Act 2025, Consequential Provisions Regulations 2026, the Draft Official Statistics Scotland Amendment Order 2026, and the Draft Common Organisation of the Markets and Agricultural Products, Fruit and Vegetables Miscellaneous Amendment Scotland Regulations 2026. Is the committee content that no reporting grounds are engaged?
Yes.
And in relation to the Agricultural Products Regulations, does the committee wish to note that it is content with the choice of the affirmative procedure for the instrument?
Yes.
Under agenda item number 4, we're considering an instrument not subject to any parliamentary procedure. No issues have been raised on SSI 2025-355. Is the committee content that no reporting grounds are engaged?
Yes.
And under agenda item number 5, we're taking evidence from Siobhan Brown MSP, the Minister for Victims and Community Safety, on the Contract Formation and Remedies Scotland Bill. The Minister is accompanied by 2 Scottish Government officials, Michael Paparakis, Policy and Bill Programme Manager at Private Law Unit, and Colin Gilchrist, Solicitor of the Constitutional and Civil Law Division. I welcome you all to the meeting this morning, and before we start, can I remind you not to worry about turning on the microphones, as that they will be dealt with by our broadcasting team. So, Minister, I'm going to open to yourself to make some opening remarks. Minister.
Thank you, Convener, and good morning, Committee. The bill that we're discussing today implements recommendations made by the Scottish Law Commission in 2018. It largely restates the current Scots law of contract formation while clarifying some doubts about the law that have crept in over the years. Contract law is vitally important to our everyday economic life and for all types of transactions involving businesses and individuals alike. Many contracts are made, carried through and become the subject of disputes between parties who have no professional assistance, and one of the bill's principal purposes is to produce legal rules that are clear, certain and accessible, and I, like most of the witnesses that you've heard from, think that we have achieved this. As you will know, Part 1 of the bill concerns the formation of a contract, and the main reform proposed in Part 1 is the abolition of the postal acceptance rule. Abolition of this rule has been a long-time recommendation from the SLC, made repeatedly over the last 50 years, and I'm glad to bring forward a provision that will finally give effect to this recommendation and bring Scots law into line with other international instruments that have no such rule. Part 2 of the bill, meanwhile, deals with the remedies for breach of contract. While this part is not as wide as the consultation topics discussed by the SLC, it is in line with the SLC's recommendations and stakeholder opinion, and when the committee has heard from a number of witnesses why the scope of this bill should not be widened. There is, though, one exception, and that is the law of retention. And I wrote to the committee in October to set out my intention to bring forward amendments at stage 2 that would reform the law. This is the end result of a period of consultation building on the considered work of the SLC and Lorna Richardson of the University of Edinburgh over the last decade or so. The law of retention is unclear, and we have in this bill an opportunity to bring some much needed clarity. And having listened to the evidence given to this committee, I'm pleased to see that there has been broad consensus on the general purposes of this bill, and I look forward to answering the committee's questions.
Thank you, Minister. I mean, you've touched upon some of this, but can you explain to the committee why the bill is actually needed and why you think it meets the main aim of making the law clearer, more certain and as accessible as possible?
So as the committee had heard from a range of stakeholders, there is uncertainty in a number of specific points around contract law. And I think there was only one respondent to the committee's call for views, for instance, that was outright against the reform. So the overwhelming majority of consultees have agreed that the law reform is needed in this area. The bill largely restates the common law on formation of contract to improve accessibility to the law and make important reforms to clarify and to modernise the law. As I said in my opening statement, the principal reform on contract formation is the abolition of the postal acceptance rule, which has been a repeated recommendation by the SLC for over 50 years now. So, yes, I think that we're just going to make the law more clearer and more accessible, and I think the committee in Parliament should take that on board.
Thank you. And can you expand on why the Scottish Government has chosen to carry out limited reform in the area of law rather than a more wide-ranging reform?
Yes, so the provisions of the bill are a result of significant law reform project which was undertaken by the Scottish Law Commission, which included 4 discussion papers on different areas of contract law. And it was clear from the SLC, from the responses that they received, that there was not agreement that in the law, in the other areas of contract law, should be reformed, and that in some areas the law would be best left for the courts to develop, and this includes issues like the battle of forms, interpretation, and also penalty clauses. So when the Scottish Government consulted in 2024, respondents agreed that the position, with the exception of the law of retention, on which I intend to lodge amendments to reform. So I see this as a very focused bill trying to make reform, much needed reform in the contracts law.
Okay. And can you briefly explain why the decision was made to allow parties to contract out of the rules of the bill?
I might bring in Michael for this one, if I may.
I mean, having default rules or parties agreeing their own contracts is a very fundamental tenet of contract law. It's spread widely across different jurisdictions, and we didn't see any. Well, there wasn't any real suggestion from stakeholders or indeed from the SLC that a change of that nature should be brought forward. It would be quite a significant departure from what the current law is, and I think from the responses that the committee will have already heard from a number of stakeholders, to go down that road would be a complete surprise and against the views of a number of stakeholders.
So with that, I mean, if that approach was taken, I would imagine that that could have probably been considered to be a bit more, maybe a bit more political as a position. And thus, this committee might not be sitting here at the moment having this, doing this work on the bill.
I mean, possibly, but I think just fundamentally, I mean, contract law has to take account of a vast range of situations, different contracts between different types of parties, and to have one set of rules governing all those different circumstances, you would have a largely inflexible system. And I think when it comes to contract law, what you need is flexibility, and I think that's what business people and indeed individuals would consider as well.
Yeah, you want certainly need flexibility, but also clarity, so everyone understands what they're doing.
Yeah, and what you have here with the bill is a default set of rules that provides the clarity. So if parties want to depart from it, they can do. Okay.
No, thank you. Ross McCall.
Thank you, Convener. Yeah, there we go. Thank you, Convener, and good morning, everyone. Sorry, my apologies. No trouble. Morning, Minister. You have already alluded to the sort of dissenting view, I think that being from Dr Jonathan Brown of Strathclyde University, that legislative reform of contract law is not needed, and that this risks damaging the coherence of common law. What's your view on that?
Yes, so I have considered carefully the comments of Dr Brown, particularly his suggestion that reforming the law of contract, we're inadvertently altering the wider Scots law of obligations and formation of trusts, wills and promises. And while the bill does put in statute law and formation of contract, it is not a complete codification of the law. So section 23A states that the provisions of this Act are without prejudice of any enactment of the rule of law which regulates any question which relates to the formation of a contract, but it's not provided by the provisions of this Act. So the law on other contractual matters is also saved by section 23, and as Professor McQueen had told the committee, Dr Brown's concerns appear to be misplaced, and I do agree with that assessment. And I did note that in the evidence sessions, Dr Brown's comments were not shared by all the other stakeholders who gave evidence as well.
Okay, thank you for that clarity. Stakeholders have stressed to us that the legislation in this area needs to be future-proofed, so that it can deal with new ways of forming contracts. Do you think the bill is sufficiently future-proofed?
Yes, I think it is, and I think I might bring Michael in, but I think this is one of the aspects of the bill is with the electronic communications. And section 13. And I know that we have not been specific, for example, with naming emails in the actual legislation, but if you go into the explanatory notes, there is guidance on, for example, if there was an outage on IT and emails there. But if there's anything, and I know that I think there's been some concerns perhaps raised by the Law Society on this as well. So I'm open, if the committee has any suggestions, or the Law Society does moving forward, if they feel that there's anywhere that we can strengthen it, but I feel we have covered it.
Yes, thank you. I mean, I think the issue is out of office, that sort of automatic reply. You're looking to strengthen that if need be.
Well, it is in the explanatory notes. It's not on the face of the legislation, which we think cover guidance-wise. And I think specifically, instead of being too specific, that's just where we are future-proofing it, because who knows what the mode of communication could be in 5 to 10 years. So this is like why we're not putting it specifically in legislation. But again, as I say, if there's, we feel that it is sufficient, but of course open to any suggestions if the committee thinks it can be strengthened in any way.
Okay, no, thank you. Finally, again, going back to Dr Jonathan Brown's argument that the postal acceptance rule should not be abolished, I was wondering what your comments were on that.
Yes, so the postal acceptance rule means that the contract can be formed without one party ever knowing that their offer has actually been accepted. And I agree with the majority of stakeholders on this, that it is at odds with a common sense expectation. The current law causes uncertainty and confusion for anyone not aware of this rule. And I understand that in practice it is commonly excluded by well-informed parties. So by abolishing the rule, I think the law will align better with reasonable expectations of most people, including small and micro businesses. And I know, as I've said several times, this has been something that's been called for over 50 years. So, yes.
Sure. So do you have any views on Dr David Christie's counter-argument that abolition of the postal acceptance rule makes sense as parties accepting offers are better placed to manage the risk of acceptance not arriving?
Yes, I do.
You agree with that? That's fine. Thank you very much.
Thank you.
Thank you. Just before we move on, when it was last week, when I was at home, I received a piece of mail that was sent by the sender on the 5th of November, and it arrived in the middle of last week. So when it came in and opened it, and I actually started to think about this. Obviously, clearly wasn't a contract, but I was just thinking about this particular aspect of the bill, and I can't comment for colleagues, but I've certainly had quite a number of constituents raise issues with me regarding delivery of mail.
Yes.
Certainly from my perspective, I think this is actually quite a timely piece of legislation. I think with the challenges that people do face in terms of getting their mail. So I think, coming back to the point about clarity and certainty, I think there probably is more with regards to electronic means of communication, in contrast to waiting for the mail.
Yeah, absolutely. And I think we will all be dealing with it in our constituencies as well, and personally with Royal Mail. It's totally different than it was like 20 years ago. So we have to move with the times.
Okay. Okay, thank you. And Katie Clark.
Good morning, Minister. And could you explain your understanding of what the main benefits will be of the new rules on remedies for breach of contract in Part 2 of the bill?
Yes. I think one of the things I think that will give is more scope on remedies to solve any conflicts between contracts moving forward. It will be clearer in this bill. I don't know, Michael, if you've got any more.
Sure. I mean, in particular, if we're talking about the law of retention, if I could just focus on that.
I was going to come on to that. So, as my next question, so
sure, I think
if you want to deal with it as in the whole, that would be fine.
Yeah. So in general, I mean, the remedies, as the Minister has pointed out, there would be clarity, and there is obviously the new remedy for restitution after rescission. So they're covering sort of gaps in the law, and they're also making clear in terms of the contributory negligence. You know, there's sort of areas there where the law can be improved. So that is the benefit by bringing forward something like retention as well. This is what's known as a self-help remedy. So it's a remedy that doesn't necessarily need to involve the court. So it's something that parties can do or take forward themselves. So, you know, there's scope there for Part 2 of the bill to actually help people keep litigation away from the courts and deal with matters themselves. And I think that's in keeping with the broad thrust of bringing clarity.
If I can just come back, I've just got specifics exactly, just to come back on your point. So the reforms for the law of remedies for breach of contract in relation to mutually of the contract, so by abolishing any rule of the law to the effect that a party who is in breach of contract is thereby not entitled to exercise any right or pursue any remedy arising from a breach of contract by the other contracting party. Another key feature of the bill with the reform for law of remedies is for the breach in relation to the restitution of benefits after termination of the contract for a party's material breach. It provides that where a contract is rescinded for breach and a party to the contract has received any benefit from the performance by another party of an obligation under the contract, the benefit must be returned, provided that the other party concurrently returns any benefit that it has received. It also includes detailed rules on the valuation of money benefits, on compensation, for example, or payment for use on improvement of the benefit of the recipient. And another one is also for remedies for breach in relation to contributory negligence by amending the Law Reform Contributory Negligence Act 1945. And I know this is all very technical, but that's just a bit more detail exactly where it goes into in the bill.
Yeah, and it's obviously been put on the record, so that's helpful. And in terms of the provisions on the law of retention, Section 21A4 states that the effect of retention must not be clearly disproportionate to the effects of the breach of contract. Can you clarify exactly what clearly disproportionate means and why that was included in the bill?
I'm going to bring in Michael for the technical side of this, if I can.
Yeah, so it was something that was consulted upon. I think currently under the law of retention, and Colin can perhaps keep me light, there is a disproportionate element already in there. So it's largely just restates what the current position is, and it's the idea that essentially, you know, if one party breaches a contract and it costs say £200 to the other party shouldn't be withholding performance that might be goods or to the value of £1 million. That's clearly disproportionate. That's not what we're looking for. Well, that's not what parties potentially should be using the law of retention to deal with that kind of breach. And I think it also goes partly to something that the Federation of Small Businesses spoke to last week about the inequality of arms between parties. So, you know, that is a kind of protection to stop the economically stronger party, you know, trying to withhold performance for what is essentially just a relatively minor breach.
Okay. And the proposed section 21DB gives courts the power to refuse the exercise of retention where that would be inequitable. And again, could you explain what is meant by that and what you envisage this would be meant to cover?
Again, that's a restatement of what currently happens as the current law. So the court has a discretion in all the circumstances of the case to refuse the exercise of detention. So it's simply a restatement. And it might be that it's difficult to come off an example off the top of my head. You know, I could perhaps write to the committee once I've had a chance to think about it.
That would be fine. So your position is it's a codification of current law and there's no intention to change the law. It's simply codifying what's already there. And obviously, if you want to write further, then that would be very helpful. Thank you.
Okay, thank you. And Jeremy Barber.
Good morning, Minister, and thank you again for coming. I wonder, what is your view of arguments made by the Royal Corporation of Architects Scotland that the draft rules of retention need to take into account the UK Government's consultation on the use of retention clauses in construction contracts?
Yes, thank you, Mr Belford, for that. I understand that the RIAS wrote to the committee expressing its view that provisions on retention should not be included, and the RIAS response to the committee seems to imply that the provisions introduce construction-specific rules into general contract statute, and this is not the case. Retention is a general remedy in the Scots law of contract, which is in need of clarification, as attested by the responses to our consultation. The RIAS also state that the provisions risk incoherence with existing construction legislation, but any specific legislation on construction would take precedence over these more general provisions, and this, to my mind, is there's no risk of incoherence. And I think Dr Christie, who gave evidence to the committee, heard from and has an interest in construction law, and he did not raise these concerns about the coherence of the law, nor has it been raised by others.
That's helpful, thank you. Just on a kind of tidying up issue, can you confirm that the new rules on contract law will only apply to contracts entered into after the bill comes into force?
Yes. So, well, no, I'm not sorry. I didn't mean to say yes. Then I just so the Scottish Government at this stage has not given full consideration to whether the bill's provisions, or some of them, might apply just to existing contracts. And I know this is not unusual for government bills, as questions about transitional provisions are often looked at once a bill's been fully considered by Parliament. Once the provisions of the bill have been agreed by Parliament, then officials will turn to questions of what transitional provisions might be needed, and there are normal provisions to enable this in section 24 and 25. My provisional view is that the bill's provisions will apply for contracts entered into after coming into force, and I think this has been echoed by witnesses who have given evidence to yourselves as well.
And I just wonder, Minister, just to follow up briefly, when do you think you will take a view on this? Will that be at stage 3 or will it be post stage 3?
It would be post stage 3.
Okay, so there would be a bit of uncertainty once the bill is passed, when it would come into force. And
my understanding is it's quite normal for transitional provisions to be considered after Parliament has agreed the final content of the bill, and this allows us to consider the best approach forward for commencement. If there's some detailed transitional or any other ancillary provisions are needed, that's better left for regulation. It also gives us the time to engage with stakeholders at the best way forward as well.
okay, I'm grateful. Thank you.
Okay, thank you. And Bill Kidd.
Thank you, Convener, and thank you, Minister and team. Can I ask, the Law Society made arguments in response to the committee's call for views that the proposals on retention risk creating uncertainty for sophisticated financial contracts. So it's about sophisticated financial contracts, and the proposals on retention could risk creating uncertainty. That's the Law Society's point of view. What's yours, please?
Yes, so my views are that the provisions, if they're agreed by the Parliament, should be by default. And as I said, I'm going to lodge any necessary amendments at stage 2. But I am willing to listen to the Law Society if they've got any suggestions in that area.
And can I ask, have you had any relations with the Law Society over this issue particularly?
I will ask Colin and Michael because they've been dealing on the official side.
Nothing specifically to talk about the retention provisions and the financial sort of contracts that Dr Patrick was talking about, but as the Minister has pointed out, the intention is that the retention provisions would be default, so parties would be able to contract out of it, which I think is what the Law Society, the point the Law Society were trying to make. And secondly, as the Minister has pointed out, our provisional view at the moment in terms of transitionals is that it would apply to contracts created after any coming into force date, so that would give time for any parties entering into those contracts to take into account the changes made, and if they so wish, they can contract out of that or make alternative arrangements.
Mm-hmm. Okay, so on that basis then, your view of the arguments made to the committee that there should be a right to contract out of the new rules on the law of retention, do you stand by that then?
Yes, I think it allows a certain degree of flexibility. I don't know, Colin, if you wanted to come in on that at all?
There would certainly be a right to contract out that the amendments will take into account that the provisions are default provisions, and sophisticated contracts that the Law Society refer to you can make different provisions. And I think that evidence, witnesses that you've heard over the past couple of weeks have that there has been support for that in relation to sophisticated contracts that there could be contracting out, and that'll be clear in the retention amendments.
Okay, that's fine. Minister, you mentioned yourself, Dr Christie, earlier as one of the witnesses, and his construction contracts speciality. What's your view of the arguments made by various witnesses, including Dr Christie, that guidance should be published on how the legislation will actually work in practice before we reach the stage of introduction?
Yes, so I'm confident that we have a bill that will make the law more accessible and more legally certain than we currently have, and that guidance will not be needed, which I understand was a majority of the view heard by the committee, so that we will be publishing the explanatory notes together with a bill which will provide clear and accessible explanation as to what the provisions do. Contracts are used really widely, and to publish and maintain guidance that accommodates the breadth of purposes to which contracts are put would be a huge undertaking. For example, the RAS has suggested that guidance be prepared for the construction sector, but any other such guidance will be limited value for other business sectors and vice versa. So yes, I feel that at the moment the explanatory notes and the guidance that will be giving is sufficient.
Okay, that's fine. And I think that's me at the moment. Thank you. Thank you.
Thank you. Minister, there have been a range of suggestions to tidy up the bill, just with regard to some kind of drafting suggestions. Is that something that you're minded to consider?
Absolutely. If the committee has recommendations, if they think it can be drafted to make it stronger, I'm always happy to consider those.
Okay. Okay, thank you. Any other questions, folks? No. Okay. Okay. Minister, thank you very much to you and your team giving evidence this morning. We may come back to you if there's any further points, but certainly thank you very much. And with that, that now concludes the public part of the meeting, and I'll move the committee into private. Thank you.